Good morning, this is your Kelso Report for Tuesday, November 6th, and I'm your host, Clark Kelso. We have two attorney fee cases today. The first holding that a plaintiff who secures favorable injunctive relief should be considered a prevailing party. And the second dealing with fees authorized by two different statutes where an offset is required to avoid double recovery. We then turn to a case involving the question of whether the jury in an assault upon a child causing death should have been instructed on simple assault as a lesser included offense. And we close with a failed attempt to stop Caltrans from enforcing the laws against unlawful advertising displays. Let's turn to our first case. As you all remember, the American rule when it comes to attorney's fees is that each side generally must bear their own fees. There are exceptions to this rule for statutorily authorized fees, fees authorized by contract, fees awarded by courts in cases involving common fund recoveries. Well, common to really all of these exceptions is that a party generally must be a prevailing party to recover attorney's fees. What constitutes a prevailing party was before the United States Supreme Court in its first opinion of this term, Lefamine versus Weidman. In a case involving allegations of unconstitutional conduct by government officials, the United States Court of Appeals for the Fourth Circuit held that a plaintiff who had secured a permanent injunction but no monetary damages was not a prevailing party under Title 42 U.S.C. Section 1988. The Supreme Court reversed in a brief per curiam opinion, noting that the injunction ordered the defendant officials to change their behavior in a way that directly benefited the plaintiff. If that does not make the plaintiff a prevailing party, it is hard to imagine what would. So the Supreme Court vacated the Fourth Circuit's decision and sent the case back for further proceedings. We also have an attorney's fees case from the Ninth Circuit. The Ninth Circuit yesterday had to deal with a situation where two different federal statutes authorized attorney's fees, and the statutes actually authorized different ways of calculating those fees. In Parrish versus Commissioner of the Social Security Administration, an attorney represented the claimant during two separate appeals, ultimately resulting in a favorable ruling on the second appeal. The attorney claimed fees under Section 406 of the Social Security Act, which authorizes recovery of fees not more than 25% of the past due benefits, essentially a form of contingent fee recovery. The attorney also claimed fees under Section 2412 of the Equal Access to Justice Act, which authorizes fees to a prevailing party against government calculated by reference to the number of hours worked. To avoid duplicative recoveries, the Equal Access to Justice Act requires a lawyer to offset any fees received under Section 406 for the same work under Section 2412. Well, the attorney in the case argued there was no duplication because he had earned the Section 406 fees on the second successful appeal, and the Section 2412 fees for prior work in the case on earlier appeals. The Ninth Circuit disagreed, interpreting the statutory language as meaning that an offset is required for representation of the same claimant in connection with the same claim, even when that representation spans multiple stages of the proceedings. The Ninth Circuit affirmed the district court's allocation of fees and calculation of the offset. The offset here has the result, of course, of giving the claimant, the client, a greater share of their benefits. Less money is diverted to attorney's fees. Next, we turn to a case involving lesser included offenses. In a criminal case, the court is required to instruct the jury on the general principles of law relevant to the issues the evidence raises. And this obligation includes giving instructions on lesser included offenses when the evidence that the defendant is guilty only of the lesser offense is substantial enough to merit consideration by the jury. In People v. Wyatt, the defendant's 18-month-old son died of shock and hemorrhage due to blunt force trauma, which apparently occurred while the defendant was engaged in fairly rough play wrestling. A jury convicted the defendant of involuntary manslaughter and assault on a child causing death, sentenced to 25 to life. The Court of Appeal reversed the assault on a child causing death conviction, concluding that the trial court had erroneously failed to instruct the jury, sua sponte, on simple assault as a lesser-included offense. The Supreme Court of California reversed and reinstated the conviction. There was no new law in this decision. The result depended entirely upon the Supreme Court's consideration of whether there was substantial evidence in the record that only a simple assault had been committed. Viewing the evidence most favorably to the defendant, the case came down to the question of whether only a simple assault occurred when the defendant executed a mock coming off the top rope move where he jumped on top of the 18-month-old who was on the bed, intending to land right next to the infant. But the infant unexpectedly rolled under him, and he landed directly on top of the infant with his hip striking the infant directly on the infant's midsection. The court concluded that, quote, despite defendant's claimed intent, given the obvious weight disparity between defendant and the child's size and tender age, and the way in which defendant jumped up and over the infant in order to land in such close proximity to him, no reasonable person would conclude that defendant's act would probably result in only minor injury to the child. Given this reading of the evidence, a reading pretty favorable to the child, I might say, the trial court did not err in failing to instruct on simple assault. Finally, an equitable estoppel case against government. In California, a government entity can be equitably estopped under the same general principles as apply to a private person. However, the courts do recognize that estopping government may implicate special public policy concerns. So, before estopping a government agency, courts require that the injustice which would result from a failure to uphold an estoppel is of sufficient dimension to justify any effect upon public interest or policy which would result from the raising of an estoppel. In particular, an estoppel will not be applied against the government if to do so would effectively nullify a strong rule of policy adopted for the benefit of the public. And because of that limitation on estoppel, the California Supreme Court has noted that the government will be estopped only in an exceptional case. In West Washington Properties v. Caltrans, the petitioner argued that its billboard, which was clearly unlawful because of its large size, proximity to the highway, and failure to be properly permitted, he argued that it should nevertheless be permitted to stay in place because it had been there for more than 5 years, and Caltrans should be stopped from enforcing the applicable regulations regarding advertising displays because of the failure to try to stop the billboard sooner. The Second District rejected the estoppel argument. Section 5216.1 of the Business and Professions Code expressly provides that there shall be a rebuttable presumption that an advertising display is lawfully erected if it has been in existence for a period of 5 years or longer. Well, the section quite clearly did not provide an absolute defense to the petitioner, and only changed the burden of proof by establishing a presumption of lawfulness. But the statute implicitly makes it clear that the public policy against unlawful advertising displays was strong enough that the legislature did not intend for the mere passage of time to block Caltrans from acting to remove an unlawful display. That's why it's a rebuttable presumption instead of a defense. There were no other facts in the case before the court establishing the sort of extraordinary circumstances that might justify an estoppel against government. So the court rejected the petitioner's attempt to use the mere passage of time as a basis for stopping a government enforcement action. And that's it for today's Kelso Report. Have a great day in the law.